This next panel is a great companion to our first panel in some ways, looking at electronic discovery and evolution of the Rule 16 in the digital era, the panel that Rob Carey moderated. This panel is looking at big data, the evolution of healthcare, RICO, and money laundering investigations. And there's really nobody more perfect for this panel, to moderate this panel, than John Floyd, who's a partner at Bondurant, Mixson, and Elmore in Atlanta. And I've had the pleasure of knowing John for many years. He is both knowledgeable, talented, and also humble about his achievements. But I believe he is probably, no doubt, one of the leading authorities on racketeering cases in the United States. People have described him as having a great depth of knowledge and experience in this highly complex area. I'm still struggling with RICO myself, John, so maybe you can help me if I buy your lunch sometime. John has written the preeminent book on racketeer influence and corrupt organizations, RICO State by State, a guide to litigation under the state racketeering statutes. And as we all know, state attorneys general are becoming much more active in this space, and so John's talents are highly sought after and needed. In particular, he's worked on a number of matters here with the Georgia Attorney General's office that received acclaim, and also he's worked with local district attorneys' offices, providing his expertise to those offices. In addition to his RICO and False Claims Act work, John conducts internal investigations for institutional clients and represents plaintiffs and defendants in different types of civil and criminal matters. John is a fellow in the Litigation Council of America and is a graduate of Emory Law School. John, thank you.
Thank you, Joe. I've been to this seminar several times and have always enjoyed it and have always learned a lot, and they finally decided that if I'm going to keep coming, I guess I should have to sing for my supper. And so this is a product of that. Let me introduce the folks who are actually going to say the things that really matter here. And from farthest to nearest, Jack Sharman is a partner at Lightfoot, Franklin & White in Birmingham. He specializes in white-collar defense, internal investigations, and compliance work, and has an extensive background dealing with really unusual, challenging matters. For example, he was special counsel to the Alabama House Judiciary Committee on the impeachment investigation of Governor Robert Bentley, and special counsel some time ago for the House Financial Services Committee for the Whitewater Madison investigation. Next to him is Erica Barnes. Erica is also in Birmingham. She's at Maynard Gale. She's a former assistant district attorney in DeKalb County in the Atlanta area, also a former assistant U.S. attorney in the Northern District of Alabama, specializes in state and federal criminal work, internal investigations, and compliance, a theme you'll hear from sort of everybody here. And nearest to me is Jamila Hall, who is a partner at Jones Day in Atlanta. She is also a former assistant United States attorney, works on white-collar defense, investigative work, and does extensive work in compliance and internal controls. Now, after a quick huddle during lunch, we decided to play with the title of this, and we're actually going to depart a little bit, and we're going to move to the one word you can never say 7 times in a seminar with Joe Whitley in the room. And then after that, we're going to transition into big data. So, big data, what is it? Before I started looking at this, I knew that it involved data, and there was a lot of it, and therefore it was big. And then as I started to look at this in a little more detail, it became apparent, and particularly because we have a PowerPoint for you that is principally Jamila's work here, and you'll see part of what we want to do here is give you examples of how data is being used both in investigations and then ultimately in prosecutions. How is this manifesting itself in different practice subject matter areas? And what, if anything, can you do about this? You know, is this something that's just happening to you and your clients? Are there things you can use here? And what are some of the available responses? And that'll ultimately feed into a little discussion about compliance. So the specific things we'll touch on are healthcare fraud, money laundering, RICO, opioid litigation, challenging big data, and compliance. So what's happening out there? And I'll run through a little introduction, and then we'll start having the panelists participate. I mean, there is, big data is more and more available to everybody, and everybody, in the subset of everybody, is law enforcement and prosecutors. Recently, I learned that data is now the most valuable commodity in the world. It has surpassed oil, and so it matters. People are willing to pay for it. It's not just a thing floating around there. It has value because it has uses. So how's it being used in law enforcement? Well, it does a number of things. You can identify anomalies faster. Law enforcement is no longer waiting for the sort of fortuitous lead that comes as a result of a traffic stop, for example, and someone's found with a bag of prescription opioids in the car. They are looking to who's prescribing opioids, who's filling the prescriptions, et cetera, and moving directly there as a lead. It allows data to be corroborated and tested and challenged. You can detect false and misleading information and provide a foundation for further investigative steps. All of this is happening. It is expanding, it's identifying matters for investigation, it's expanding the scope of the investigation, and subject to some of the things we heard from the first panel, it's expanding the speed with which the investigation moves. So one area we thought we'd start with is healthcare. My guess is, show of hands, everybody here do healthcare work in some form or fashion. That's about what I thought. Okay, so today we have strike force teams. As you can see from this map, there are about 25 states the federal government doesn't care about. But there are also about 13 that they apparently do. And of course, the strike forces, while these are geographically centered, there are assets they can deploy anywhere in the country. But one of the things that they are particularly touting is their use of data analysis. This is something that the strike forces are proud of. They're getting greater budget allocations every year. They're developing greater expertise, and they are happy to tell anyone who will listen, this is a central part of their efforts. And so, Jamila, using this slide, can we kind of talk about how this is being used and how it's moving over the life span of a case?
Sure, John, and good afternoon, everyone. It's always a pleasure to be here. Joe, Brian, thank you so much for the invitation, because this is just a great conference and a really wonderful group of old friends, new friends, celebrities like Nina Marino. Thanks for coming up from the other side, meaning the coast. You're always on the right side, Nina. But well, not really. That is true. As am I. But looking at this chart that we put together, the way that the various agencies are looking at data is they are figuring out, okay, let's say we're talking about opioid prescriptions, and we're using opioids a lot in this discussion because that seems to be where it's sort of most of the examples of the use of big data are right now. And of course, we'll talk about where we think things are headed. But if you look at opioid prescriptions and claims in Medicare cases, they'll look at the number of prescribers and then they'll look at the number of prescriptions per prescriber, and there'll be some standard that is set in terms of what they think should be happening on a daily, weekly, monthly, such and such basis. And once they identify a baseline, then they're looking to see, well, who's prescribing above that? And of the people that are prescribing above that, how much above that baseline are they prescribing? And at some point, do we need to do something? And there are sometimes that there are reasonable explanations for some of these outliers. And so the hope from those of us that are in the defense side is that those outliers that might have reasonable explanations are quickly investigated and then dismissed. Those that do not have explanations, of course, then they are going to be further investigated, and there's going to be potentially some undercover operation going in, feigning some, make-believe pain in the back to see if there really are prescribers that are over-prescribing. And so once that happens, then of course they start aggregating that data and doing a look back to see whether they can build a case of a greater fraud operation in that perspective. And we can see that happening in healthcare fraud cases that are outside of the opioid litigation. Simply looking at claims, several folks that I've been talking to since coming here, we have the impossible day cases. The physician that somehow manages to see 80 patients in one day, 2 or 3 different locations. It's now through analysis of big data, looking at what the baseline is, or what, and this is arguable and something that we often are challenging now, is who's developing this baseline? Who's setting these standards, and what are they really based on? But at any rate, the department does pick one. They pick a baseline, and then they're looking for claims in those cases where you have either the impossible day or the prescriptions that are going well and above what others would consider to be normal in the ordinary course of medical care. And so this slide is looking at that specific example where you have HHS actually looking at using machine learning to look at home health agency cases to detect potential hotspots of fraud. So they were looking at high percentages of various episodes. One where the beneficiary had no recent visits with the physician. So they're just constantly billing for home health visits, but there's no way to determine whether that patient even had a need because no physician is going to check on that patient. Or where there wasn't a hospital stay, where they actually had a benchmark for the patient's health at a particular date and time. And so that would dictate what you would think would be coming in terms of a length of home health aid following the hospital stay. So there are ways that machines are now doing what case agents used to, and so we're seeing a lot more big data in the healthcare sector.
And this slide is based on a national investigation. So data from across the country was assembled, and as Jamila pointed out, and we'll point out again, someone made a decision, some person developed criteria for what is an outlier. Now, sometimes that can be easy, like the patient died 6 months earlier, so there's no judgment there. There is now no longer a patient. But in most other circumstances, there is some subjective component in this. Somebody has to decide what constitutes an outlier. Is that correct or not? And was it consistently applied? Those become very, very important questions because this is assembling this data to basically go through a targeting process. And at the far end of this, there will be potential targets and subjects. Agents will be deployed, there may be subpoenas or administrative demands, et cetera. So this is getting it all started, and often for the defense bar, this is under the surface. I mean, this is the part of the iceberg nobody sees. We'll come back to healthcare as we go along in this and other manifestations, but I just wanted to illustrate that. One, we're also, they find 500 agencies and 4,500 physicians who were outliers. Well, probably all of them didn't get subpoenas, didn't get visits, there weren't search warrants there. So there's a constant culling process working down in which finally entities and individuals are being identified as being worthy of direct, focused effort. That process is going to become critical. Money laundering.
And John, before we leave healthcare, just want to make sure that we get to this. I think for me, one of the most disturbing things about this on the healthcare side as a defense lawyer is One, I think they were doing and are still doing what Jamila talked about, which is to use big data as an investigative aid. And I had less problem with that, right? Let's find the bad offenders and go investigate. The problem, I think, especially with opioids, is there's more and more pressure to bring more and more cases. The data is no longer just an investigative aid, it is the case. Mm-hmm. So you take the data and instead of going, okay, this is the person I should go look at, and now I'm gonna go do real things like send in undercovers, actually talk to people, look at documents. The data has just become a shortcut. So it's like the data looks really bad, and now I'm gonna do the minimal level possible. You know, I'm gonna have somebody drive by the clinic 3 times and talk about, you know, how many people are there. And so to me, that's really scary because data, even more so than human intelligence, is susceptible to manipulation, and it's junk in and junk out. So if you have a client who has bad data practices or bad record keeping practices, all of a sudden you got a whole bunch of crap out there that looks really, really bad. And you may have to wait a long time to be able to sort of debunk that, or even try to debunk that. Just as an example on the PD&P side. So if you got a physician who has 5 nurse practitioners and the physician is running every prescription through the physician as opposed to the nurse practitioners, not best practice, but obviously it happens. Now you got 6 people prescribing, but based on the data, it looks like it's coming from one person. And how you get around that once that's out there is, so in the money laundering space, right, it's always been an investigative tool, BSA type data, but now the data is the evidence. And I think to me, that's really a disturbing trend.
And one of the things that we'll talk about a little later, Jack's been kind enough to give us exhibits that were used in a trial involving one of his clients, and you'll see how this investigative predicate ultimately turns out to be the evidence in the trial itself. And it is, you know, it's pretty powerful stuff. You're gonna have to deal with it. Money laundering, I mean, to my mind, is sort of one of the original big data areas where a statutory scheme required as a condition of engaging in certain areas of business that banks and other financial institutions provide the government with information. Once upon a time, those were sheets of paper. That's not really the case anymore. And as with many other things, the amount of information provided to the government has expanded, the requirements have expanded, and the information is, in some respects, more readily accessible and analyzable by the government. And so, Erica, what are you seeing the government do using this big data now?
Well, I think there's a big push in the money laundering space because if any of you represent financial institutions, which I do, they're pushing back. I mean, the cost of doing this is astronomical and is growing every day. And it's no longer just banks. Now it's casinos and, you know, you've got an ATM and a bar, so you're a money servicing business. You know, it's everybody. So people are pushing back to law enforcement and going, show me you're doing something with this. Because if you're not, why am I spending so much money and hiring 30 people to collect this crap if you're not going to do anything with it? And I came from a smaller U.S. Attorney's office, so you know it was an issue there. We would have these huge, you know, SAR task force meetings, and everybody's looking at the data, and nobody wants to do the analytics, or you know, the data makes a handful of cases a year. And I think the industry is starting to push back. So in response to that, you know, the FBI now, I don't know, John, whatever the statistic you found, we're up to somewhere around 20% of all FBI cases where they say, okay, BSA data made a difference. We used it. We used it for something. So I think there's a push to law enforcement to use this stuff because the financial services lobby is now pushing back and saying, if you can't show us this is useful, or it's actually stopping anything, then why are we doing it? And I think that's the most interesting things going on in this space, I think, is what's going on with crypto, which is, you know, people moved to crypto so they could get away from all of this sort of regulatory data and privacy issues, or if you're a prosecutor so they could commit crime. It depends on your perspective.
It's an investment for me.
Yes.
Before we go to crypto, can we back up just 1 second? I wanted everybody to see one thing here. I mean, here you get a sense of the different categories of information that are now being gathered under the Bank Secrecy Act, Secrecy Act as it exists now. And this is a dramatic expansion over what we began with in the 1970s, a lot of it as a result of 9/11 Patriot Act. And so we have the pendulum swinging. At a time, the government basically had a blank check to legislate and gather whatever they wanted to gather. Now there is some pushback because of expense. But it is an enormous amount of work. It is part of a compliance program, just like healthcare has compliance. And one thing I wanted to highlight is that companies are gathering their own data, financial institutions are gathering their own data as part of their compliance programs. But what that means is if they don't follow that compliance program, the data they're mandated to collect or that they've chosen to collect as part of their compliance program becomes evidence of their own violation of the law. And there are two recent examples of in-house financial compliance officers being pursued by the SEC and the company being fined. And literally the complaint is very simple. They name them, they say what they did, and they attach their own compliance manual. And it basically says, this is where you were supposed to do this. And if you found this information that your system surfaced, this is what you were supposed to do, and you didn't do it, goodbye. That's it. Very difficult to defend against. And they literally, SEC literally said, these aren't red flags we've identified. These are the red flags you identified in your own manual. You identified them and then did not report them. So it was intentional. You basically wrote down what you were doing. I wanted to just touch on that. And then, I'm sorry, we were going to crypto.
No, we were looking for something to talk about in the money laundering space, and crypto to me seems the most interesting because of the traditional BSA data. Again, I think it's more useful to prosecute financial institution compliance officers than it is sometimes to prosecute criminals. But the crypto issue, I think, is useful and interesting because you're seeing the tension between privacy advocates, people who are saying, okay, you told me that if I want to take advantage of the banking system, then I have to live with the BSA. Okay, I just won't take advantage of the banking system. I'll go over here. And the government says, no, you can't go there either. Like, I'm going to move over here with you. So there, if you're following the whole Facebook, their attempt to develop crypto, all of a sudden the regulatory community is up in arms because they're afraid if Facebook has crypto, people will actually start using it. And we don't have an AML regime in place to address it. And it's not a legislative issue, it's a nuts and bolts practical issue, right? You can mandate that cryptocurrency comply with the BSA, but how is that actually going to work? There is no CTR for a cryptocurrency transaction. How is that gonna happen? So I think we're gonna see a real tension again if we don't get reasonable about sort of what's going on here and how we're using this data. Are we using it in a way that really makes investigations and is useful? What's sort of coming next in the crypto space?
And just one final thing in this area is that the government has had a number of very successful prosecutions in the crypto area, and they have gathered a lot of information. So there's a bit of a disconnect out there because a lot of folks, some of whom will become your clients, the attraction of cryptocurrency, if you get rid of the sort of quasi-religious fascination with the inventor of Bitcoin, and some of the other things, it is secrecy. I mean, it is the fact that this doesn't generate records or so people think. But they may not be thinking about the fact that there are now several years of investigations that have uncovered all kinds of information. And all of that information is available to be used to develop other investigations. So in other words, it may not be anywhere near as confidential as a lot of folks are assuming it is. Okay, RICO.
Just a quick point, John, on the crypto for people whose clients do think that they do have a level of secrecy. I mean, it's with any other transaction where when you buy and sell, there's a trigger. And so when you're buying and converting US dollars or whatever currency into Bitcoin or whatever crypto, there is going to be a record of that. And then when you exchange it back to US dollars or whatever currency, there is going to be a record of that at a minimum. So law enforcement does have you on both ends. Now, if we get to the point one day where you're able to purchase a house in cryptocurrency and never have to exchange it to US dollars or another currency, then we might get to the place where we really do have some considerations about it not being traceable. But right now, as long as people are still having to convert into the currency and then convert out of it, it is for all intents and purposes traceable. And no matter how much you encrypt your actual Bitcoin in the locker, I had to buy Bitcoin, so I understood all of these things. And I still am interested in who is the inventor. Nobody really knows. It's just some universe out there. But in order to keep it in a locker, that doesn't necessarily mean that when I purchased it, there wasn't a transaction. And this comes up in the tax fraud context, where they are using Bitcoin, because lots of people had purchased Bitcoin when it was rather low, sold when it was at $20,000 a coin, and had a huge tax impact and thought that they had gotten away with something great. But no, when they purchased the Bitcoin, they had to use cash. And then when they converted it back at the 20,000 mark, so when the IRS started calling around, people were wondering how could this have happened? And it's because of the triggers that come when they exchange.
And then now you get into more traditional methods of law enforcement, like whistleblower programs, which the IRS has, interviews of former boyfriends, girlfriends, spouses, and business partners. Yeah. Because nobody who does that fails to tell at least three other people what they did because they're so proud of it.
And just to play off Jamila's point before we leave crypto, even beyond the entry and exit to the system, if you ever represent drug criminals or violent criminals, right, they've gotten around that, at least a part, right? They're not buying on licensed exchanges. They're doing it in a different way. But because of that, one of the more interesting things that law enforcement is doing with data is the analysis of the blockchain itself. Yeah. Mm-hmm. So they're getting, when every transaction is recorded, that's the biggest set of big data that there is. And now that we're using chain analysis and other data analytics programs to do that, even if you don't buy in or cash out, we can still analyze the data in the middle and lose the anonymity that way. So.
And so, to some extent, the healthcare cases and the money laundering that we just talked about, they sometimes get pulled up in the water spout that is known as RICO. And those of you who know me well know I have an interest in this level that's positively, in this area that's positively unhealthy. So I'll restrain myself and not go into it too deep. But the federal government, money laundering has always been one of the predicate acts. It's been used fairly often in RICO prosecutions. Healthcare-related fraud is starting to be used. We're seeing RICO in criminal opioid-related prosecutions and in some healthcare prosecutions. We're also seeing it be used by states. Everybody tends to think of federal RICO, and seminars like this tend to be very focused on federal law, but there's about at least 25, more like 30 state statutes that have criminal components, and some, like Georgia's, incorporate all the federal, in their definition of racketeering activity, everything that is federal racketeering activity, a list as long as your arm of state violations, and then generic categories of violations under other states' laws. So the footprint of those statutes is enormous. They aren't used terribly often Georgia has used RICO in opioid prosecutions and money laundering prosecutions. Some other states have, and there's a host of, we'll touch on it a little bit later. In the opioid space, RICO is a claim that's being used in some of the attorney general cases, the civil damages actions that are part of the MDL. Most of them are part of the MDL in Ohio. But big data in this area, just to touch on it for a minute, is useful because there are basically two principal components of a federal RICO case. A pattern of racketeering activity, those are the kinds of things we've been talking about that can be developed using big data the way that has been mentioned, and then the enterprise. That may be an institution or it may be in an association in fact. Big data is incredibly useful for showing an association in fact enterprise because it lets you search across a huge amount of information to find every single way in which different actors dealt with each other directly or indirectly. You can mine social media, you can mine financial transactions, you can go through all the kinds of things we're talking about, but this is where, this is where the Facebook, the phone, all of these other things start to tie people together in some ways that are innocent or perhaps open to judgment decisions and some that aren't. And so this is where you can start to see, why is this person using cryptocurrency now? Or why do they use it only in this kind of transaction and no other? Does that cryptocurrency transaction provide some kind of link to someone who you want to put in when you're identifying the enterprise and when you're proving it? Because you're going to have to show not only that they associated, but that association had some purpose that ties to the acts of racketeering activity. And the government is using all of these tools to build these kinds of cases. So we started a little late and I'm going to jump ahead because we've already talked a little bit about dark web and some of that work. So I'm going to go to opioid litigation now. And the reason we wanted to include this is that frankly, the opioid issue has become a litigation theme park. I mean, there is almost no theory of liability that isn't being used. There's almost no asset that isn't being deployed in this area. And the government is not making any bones about it. They have announced, they've created new positions, they've created task forces, they have the amount to which agencies are being tied in together in cooperative efforts is enormous. And they aren't all just law enforcement agencies. CDC is playing a role in these. It is a comprehensive approach. I went to a summit in Atlanta about 6 months ago talking about this, and there were folks from agencies involved in healthcare, and in law enforcement, et cetera, and they very proudly said that the total federal spend for 2019 had increased to $900 million. And that was almost doubling in about 4 years. It's going to $2 billion next year. Now that's not all law enforcement, but that gives you a sense of how deep and consistent the federal government's focus is in this area. And so we have just a sense here of how this is a priority and a little illustration of it. In the back, you may have a little trouble seeing it, but Jack, I know you're seeing these investigations. I think you all are working on matters that touch on opioids. So how is this sort of manifesting itself in your day-to-day practice?
Well, first I want to commend everybody in this room, because you're sitting here in a darkened room after lunch listening to a panel about data. I'm having a great time because I like working with these people. If I were in your seats, I would rather remove my toenails with a blowtorch. So stick with us. Big data, at least in my experience, and in particular in opioid litigation, it touches several points. One is the one that John just mentioned, which is these cases can be charged, among other things, as RICO conspiracies. And it certainly helps the government both in shaping the indictment and in proving up the case if they have a way to marshal that data, which they could be a great deal in a large practice or in a large physicians group. My partner Brandon Essig and I 3 years ago tried a 7-week opioid case in the Southern District of Alabama. Our client was Pat Couch. Pat was a board-certified anesthesiologist who, with his partner, Dr. Shuli Ron, ran a very large and, for a while, very successful pain management clinic in Mobile. He and Dr. Ron were charged with an impressive suite of offenses, including violations of the Controlled Substances Act, RICO conspiracy, and so forth. Dr. Couch and Dr. Ron were both convicted on all counts, and Pat is currently serving a 19-year sentence in the BOP facility in Arkansas, the government having asked for life. That case is on appeal to the 11th Circuit and was argued 2 weeks ago tomorrow. And one of our points on appeal was the use by the government at trial of the PDMP, and in particular the Alabama PDMP. And I think the brief is in your materials. Just read our brief, don't bother with the government's. But the interesting or useful thing for, I think, this group is that the government offered the PDMP data essentially whole in evidence. As you probably know, there are arguably 2 levels of hearsay in a PDMP. First, the pharmacist makes a statement by inputting the data, and then the record itself, of course, is a statement of the Department of Public Health. Rather than calling pharmacists from the inputting organizations, the government offered simply the inputted data through Nancy Bishop, the lady who does such things at the Alabama Department of Public Health. We objected both on hearsay grounds and on confrontation grounds. There was nobody to cross-examine on the methodology, the accuracy, the scope, the integrity of the data that was being entered into the system and offered as evidence of intent, really, against Dr. Couch. So there's a hearsay issue, there's a confrontation clause issue. We will see how the 11th Circuit treats that. There was an atmosphere with Dr. Couch's and Dr. Ron's practice that was reminiscent of sort of Italian opera at its lowest. And I can regale you with some of those aspects of the cocktail party. But overturning the verdict on appeal may be unlikely. The other striking use of big data at trial was in the form of exhibits that the government offered, not only as demonstratives, which would have been difficult enough to deal with, but actually as substantive evidence that the jury took back with them. as my colleagues have pointed out, at least in healthcare and certainly in opioid litigation, the focus on the data is on volume. If we're big, we're bad. This is not a field in which we want to be a leader, especially if the scale of our volume leadership, our prescriptions, is significantly greater than, say, those 5, 10, 15 places before us. And how do we make decisions about either valuing a number of things or making a decision between two binary options, guilt or innocence, intent or lack of thereof? Well, we tend to rank, or we look for a ranking, or we try to identify somebody or somebody of knowledge that seems authoritative that can give us a sort of a go-by. And that's what the government did to great effect and over our vociferous objections at trial. And John, I don't know if you are able to
It's a little further back, but
pull up, but while I'm on the subject, I think it's maybe about 60 or so.
Take me a second to flip through
Sure.
it, but now's a good time to display it.
So what we had were rankings, so like 58 is a good 58, 59, 60. So what we had basically two things. We had rankings, sort of like this is, the SEC West or something. And one of our objections, of course, was that this really shows the jury. It's not helpful to the jury. It doesn't show anything except volume. And of course, that was the government's theory that that big is bad. It can't be that this kind of volume can be legitimately supported in South Alabama or North Florida. Now, there are ways to try to contextualize this sort of attack at trial. For example, we put on evidence that the concentration of physicians and pain management doctors makes a difference. So that, for example, in Massachusetts, which has a very high density of both physicians and pain management physicians compared to the population, this would be extraordinary. In South Alabama, North Florida, where there aren't that many doctors relative to the population and not many pain management physicians relative to the population, it makes sense that if you have a successful practice, you're going to have a lot of prescriptions. We were allowed to put on that evidence. The jury didn't really care. I think that as many of us would, they might be sort of overwhelmed by data. And then, John, if you could skip over maybe to the pie chart, which is at 60.
Yep.
These kind of visuals are very effective. And again, we went through the same arguments, which I would encourage you to undertake, which are plain, old-fashioned, evidence-based arguments, all of which were rejected really in the interest of efficiency. The government offered, for example, seized patient records from Dr. Couch's practice. We objected that there's been no foundation for a business records exception. The government said, well, they were found at a business, and the judge said, makes sense to me.
That's awesome.
So these kind of exhibits, which, as you can see from this one, actually went in evidence and go back to the jury room, can be very powerful in the hands of government jurors. In other words, when you get a government juror in deliberation, they show something like that to one of your jurors, that's going to be a pretty powerful argument. So there's some more of these examples in your materials, but I do encourage defense counsel, not just in opioid cases, but in any healthcare trials where there's significant amounts of data susceptible to being graphically represented, object like hell, and try to put it in context. I think the last piece, at least in this part of the discussion about opioid trials and big data, also relates to sentencing, because one reason Pat's sentence was so high was because when you, as you know, when you get into the tables and the sentencing guidelines, you have these marijuana equivalents and so forth. And when you start doing the math with a large prescription practice, you very quickly get up the sentencing table. In fact, Brandon was so bored he left. But I think his guidelines range was in fact something like, it was 18 years to life. The government asked for life, and the reason it was so high was because, again, the government was able to marshal all this data and offer it in order to drive the sentencing calculations, and we really had no legitimate basis to dispute that.
Well, I guess this may be a question for the audience, since Jack, you said you didn't have a legitimate basis for this trial to dispute it, but is there any sort of attack on the reliability of the data that can be used from a defense perspective? If you get an expert to come in and do an analysis, I mean, is other than objecting on hearsay and confrontation clause issues, I just wonder what else we can do as defense lawyers looking at that data. Anybody have any words of wisdom to impart there?
Or has anybody gotten it?
Yeah.
Because I think that's what's most interesting about the PDMP is you get the data for the client, but the government, they're ranking, but you don't get the data for the guy who's ranked next to your client.
Mm-hmm.
I think there's an advocacy problem here, though, because what you have on the screen highlighted is the legend that appears on the bottom of every Alabama PDMP report. And it says, don't rely on this. It said this is an unreliable document. And again, this was another objection we made. It said, Judge, we really should not be admitting evidence that is not only not self-affirming, it is affirmatively self-destroying.
It's absolutely unreliable.
Again, that fell on deaf ears. But I think this is a common kind of problem, recognizing the data problem, which is, in fact, the PDMP is designed appropriately for a variety of purposes, including investigation, law enforcement, public health, so that physicians can check, cross-reference their patients. It is not really designed for trials in which lay people are going to decide whether to send somebody to prison for life or not. Hence this kind of warning. But as John and my colleagues said, there is such a groundswell of feeling in this area that that may not make much difference.
When I first started practicing, it was before the formation of the 11th Circuit. We had the former 5th Circuit, which was famous for its aggressive approach to desegregation and was viewed as a very liberal circuit, applying that term in a not very precise way. But it was explained to me that the former 5th had something called the drug dealer exception, which just meant drug dealers' convictions were affirmed. And that was, in essence, it. That was a while ago, but we're now at something similar, because the theme in these cases is always that the doctor is simply a drug dealer who has a white coat and a degree on the wall. There are cases where that approach is pretty convincing and has pretty solid basis. There are cases where it may be much less so the case. And so one of the things that we're talking about, and I'm going to skip a few slides here because we've, as This is all naturally unfolded. We've defeated the genius of my PowerPoint in some respects. But when you look at this, one of the things that becomes apparent, and I said this early on, is somebody's making judgment calls. And so sometimes you get what's just a list and a ranking, which is what Jack's talking about. And someone's taking all the information that's been put in and they're developing a ranking from it. But in many circumstances, there are judgment calls that have to be made. What are you going to collect for a specific purpose? How are you going to review it? And are you actually going to review it all? Because one argument the government has in Jack's situation is, well, we did collect it all. Everybody does have to give it to us. We really did put it in here. And whether we're warranting it or not, we didn't leave anything out. There weren't any judgment calls. It's just a matter of how many prescriptions did you write for this drug or that drug or the other drug. Our DEA's ARCOS data is similar to that. It's just omnivorous. It just hoovers up absolutely everything, and then you can look at it afterwards. But in many circumstances, there are judgment calls being made, and I'm indebted to Steve Pierce and Kate Frost at Price Waterhouse for spending a very patient lunch walking me through some of this stuff and giving me an example to illustrate it. But there is a thing, some of you may know about this is news to me, but it's called a waterfall analysis. And in essence, as you go through large amounts of data, you start out with a very big number. Here, it's over 25 million is the original population. And then a series of exclusion decisions are being made until finally a much, much smaller amount of data is actually going through the full analysis. So at each stage in this, somebody or some group of bodies has to make a decision, we're not going to look at that anymore, or we'll come back to it, which usually means we're not going to look at it anymore. And you end up with a result. And one of the things that is happening here, we have a couple slides on it, but I'll just describe it verbally in the interest of time, is that there's data that the government gets, which then becomes available to private parties, which then analyze that data for entirely different purposes. And so one example is healthcare claims, reimbursement claims. There are companies that have their own data analytics units within them that have been developed, or they have purchased them. That can be for a bunch of different reasons that are perfectly legitimate, but they can also become tools of fraud, where the analysis is to identify somebody where, say, the complexity, the classification of the treatment can be elevated. And so you're opportunistically looking for that person. You're going to move from 3 to a 4 or a 4 to a 5 because the amount of reimbursement tracks that classification. At the same time that they're looking at the data the government's getting. At the same time, there are relators who are using data analytics to identify exactly that behavior. And they're looking at what the publicly available government information, and then they're also looking at what the healthcare analytics companies say about themselves, and putting that together and filing False Claims Act cases. And one of them recently survived a motion to dismiss, which was an original source challenge, basically saying you're not doing anything other than just reading the government's information. And the response was, no, we're analyzing it. We're doing this stuff. Okay, wrong button. We're doing this stuff. That's the stuff I meant, okay? And so that's not just parasitic. There is work. It's a lot of work. It's expensive, and it requires special skills. And we're doing it because the government can't do it all the time. But consider the possibility that if the government also analyzes it, 3 different actors will look at non-identical but substantially overlapping sets of data, each making their own decisions that have a subjective component of judgment in them, and each producing an ultimate result. And I will bet you those results are not identical.
Well, I think that's actually a really good good point, John, because at least in the Northern District of Georgia, one of the things that we've been doing is the government tends to use the same expert for a lot of these cases if they go to trial, certainly. And looking at that expert's prior testimony and the things that they pick out, Jack, for example, the charts that they chose to use in one particular case, if in that second case, they're not using those same types of charts and coming to those same types of conclusions, there's likely a reason. It's likely not helpful for them. And using that as a cross-examination tool in terms of, well, this is a test you always run against this data, but you didn't run that here, or at least you're not disclosing or you're not discussing that to the government's benefit here. Those are ways to attack the process, because people can use data to come out with all different types of conclusions, but when you've got a known quantity like some of the government witnesses, that you can go back and look at the things that they focused on in particular cases, and you can identify the holes in what they're presenting in your case, it's actually quite compelling to realize that they know, and this is, BJ, this might be helpful for your Supreme Court issue. That's Brady, I would argue, right? And we were talking about that before, but that's Brady. If they run these tests and they come out and it's not helpful like it was in Jack's case, maybe they need to be telling us that. But until we get to that point, we need to be figuring that out ourselves and using that as, as a sword in cross-examination.
And so one of the things that I learned is that, and some of you may have encountered this, in software development, there are logs. And the log records each change that's made to the code, so that it's possible, in most circumstances, to actually go replicate an earlier version by, in essence, peeling off the changes. In the same way, when these decisions are being made, there should be, I'll use the term log, I don't know what the actual term of art is in this area of forensic endeavor, but there should be a record that says this is the decision that we made, and this is what we analyzed, this is what we excluded. So one question becomes, did the government keep that record, and can you get to it? Generally be easier to do in civil litigation, right. But I do think the Brady concept has some application here. And it's not, now the worst possibility, best for the defense, worst behavior, would be that this was pernicious, that somebody has looked at this and is truly manipulating the data in the sense of manipulate to achieve a desired outcome, as opposed to conducting an objective analysis. But setting aside even a malevolent purpose, there is the simple fact that the judgment may have been poor, and it may have unintentionally produced a result that is incomplete or inaccurate or misleading. One of the questions that I would want to know is, how many times did you do this analysis? Are there other analytics that were done that you're not showing anybody? And that ties into somewhat what Jamila was saying, but what is the full picture of how this was done? And in essence, did somebody have their thumb on the scale intentionally, or did they just forget to take the 10-pound weight off the scale when they were measuring what the weight was? These things become important, and we had promised to talk about compliance a little bit, so I want to scroll back.
John, before we do that, just to
Yes.
so that we all don't leave with like a giant bummer, because that's where I am right now. There's a lot of they're doing this with data, they're doing this with data. What can we do about it? We've got some information in the materials about suppression. I think what Jack's trial teaches me is that if the data gets in and I'm having to argue waterfall theories and put my experts in, I'm toast, right? Because the jury doesn't understand it. They don't care. They're going to look at the big red pie chart and my guy's dead anyway. So how do we keep it out? And so I would encourage people to think about that as well. And, if you're a little bit of a Fourth Amendment nerd like I am, Carpenter did some good things. It's about cell site data, but it gave us some good tools. And people are now using those tools in white collar suppression motions, especially in these opioid cases. There's one pending in the 11th right now, with the notion that you should have had to have a search warrant to get to this PD&P data. Everything you got from the PD&P data falls from that. It should have all gone. It's suppressible. So if I can keep the big red chart out, that's my goal. So there are some unique arguments out there, and least we all leave with a feeling that we can do nothing. I would say, try to keep it out first. If you can't keep it out on suppression grounds, try to keep it out on evidentiary grounds and hope that your judge knows the rules of evidence better than Jax did. And if that's not an option, then I think you go to option 3, which is, use it. Try to cross on it, or try to find something positive in the data that you can use. But I just didn't want us all to leave with the feeling that there was nothing we could do.
And I do encourage you to read Erica's suppression materials, because for whatever reason, a lot of white-collar lawyers don't file suppression motions. It may be because they lose 99.8% of the time. We just don't like to lose. But as opposed to lawyers who do more blue-collar crime, who are very comfortable with suppression. And I think that is really something that a lot of people in rooms like this tend to overlook. And even if you lose it, if part of your basis for suppression is unsavory conduct or ignorant conduct by the government, you will have at least begun telling a story to the judge that may help down the road.
Yeah. And so Erica has left us with maybe the most important lesson, which is scare the client, encourage the colleague. But in mentioning Fourth Amendment, how often are people seeing, both on the panel and in the audience, seeing data being used as a basis to obtain a search warrant, or as a basis to support a Title III application, pen register application, et cetera? Because my impression is it's increasing, and it's increasing a lot. And pretrial suppression hearings may give an avenue to attack that would, gives you a much earlier look and perhaps some traction with the judge, where if it, as we're hearing, if it's happening at trial, it's just maybe too late.
John, can I poll the audience really quick just to see if anybody's done this? So I'm really interested if anybody has seen people make data arguments in the same way we would make informant arguments, right? So there has to be something in your search warrant that's, telling me at least some person says this informant is reliable, has provided reliable information in the past. If I'm using data analytics as the basis for my search warrant, and there's nothing in there about whether this data has been reliable, effective in the past, or in instances where it's been ineffective. So, this agency has used this kind of data to support search warrants before, and it turns out that it wasn't a pill mill, or it wasn't. Has anybody seen that argument made anywhere? Does it sound bizarre? Would anyone accept it if I made it? I mean, I haven't found the case law, but I think that's something we can say. Because why is the standard for data any lower than the standard for Joe Schmo who came and told the cop one thing?
Well, and I
The judge's panel is next, so we'll save that question.
yeah. Well, and I can tell you that I in the civil litigation perspective, I've been looking at opioid-related matters for about 6-7 years now, and that's included reading transcripts and pleadings in a whole huge number of criminal prosecutions, and the data is being used in search warrant applications. There's no question about it, and it seems to be accepted somewhat uncritically, I think, just because the challenges that you're talking about have not been made. So maybe next year we'll hear a little more about that. I did mention at the beginning, and we've alluded to compliance issues a little bit, and I wanted to take a couple of minutes to talk about this. A lot of folks in this room do compliance work. A lot of them advise corporations and compliance officers, et cetera. So I thought this would be pertinent, and there are a couple of examples. I mentioned one in the money laundering space, but this has come up basically in the last year significantly in the opioid space. And one example is the indictment of Rochester Drug Cooperative. which is one of two opioid distributors that have clashed with the federal government in the last year or so. And in the Rochester case, there were charges against both the CEO and the chief compliance officer. And because in this area, under the Controlled Substances Act and the related DEA regulations, there has to be a compliance program. It is mandatory. You lose your DEA registration if you do not have a program that is effective at detecting diversion. And diversion is basically any unlawful or unintended use of the drug. And there's a massive amount of data here because DEA tracks particularly Schedule IIs through the ARCOS database about the way that the military tracks nuclear warheads. I mean, it literally is, from constituent components all the way to the manufactured drug, all the way to the pharmacist, and being administered to the patient or put in their hands in filling a prescription. So it's an enormous amount of information. But because these companies have to have compliance programs, one of the things the government has done is look to them to see, are you following your own compliance program? And where the answer is no, this now becomes intent. You're now no longer talking about just, was your compliance program actually robust? Because as everyone knows, every compliance program is, robust, okay? And it doesn't matter that this is the 5th iteration of the compliance program that's failed 4 times before. They were all robust. Why? Because somebody said so. But not having a robust compliance program may be a regulatory problem. It could be a civil fine problem. It could be a licensure problem, and ultimately it could be a criminal problem. But not following your own program and having dramatic departures can really be brutal. And in the Rochester drug case, they flagged 8,000 orders of interest. And the allegations don't tell us what the criteria were for identifying an order of interest, but it was something that their compliance program said, this deserves further analysis and inquiry. So the first step in that waterfall. Well, at the end of the waterfall, only 4 suspicious orders were reported to the DEA, even though 3,000 of them involve Schedule IIs, which are the most frequently diverted, most frequently abused, and most deadly, particularly fentanyl. That led to criminal charges. There is another that I wanted to point out. Miami Lucan, I think I overshot that one. Yes. Conspiracy to distribute and dispense a controlled substance. Also had pharmacists charged, but again, the former CEO and the former, it should be CCO, also charged in this case. Again, not following their own criteria, and ending up, oddly enough, the end result was almost nothing was reported to DEA. Nobody's getting charged because they flagged too much. They can get charged because they flagged too little. So this is a situation where, somewhat like anti-money laundering, it's a government mandate that some level of this analysis go on. There's no choice about whether to do it or not. And so the first question is the program adequate and effective as is required? The second one, which doesn't necessarily depend on the first, is, are you even following your own program, even if it's not that reliable? And failure to do so can bring really serious consequences in that context.
We have a lot of folks in the room that also do work outside of the opioid space, like in the FCPA compliance regime. And this is a place where we've found that using big data has actually been helpful for companies So when we're talking about FCPA compliance, we're usually looking at training programs, making sure they have a strong code of conduct, making sure there's an auditing procedure and a hotline and the like. But instead of waiting for a hotline or worst case scenario, whistleblower complaint, there are actually analytics that can be run on travel and entertainment data, for example, looking for triggers, whether you're having meals with government officials too often, even if they're small dollar amounts, or are you having, are there expenses for which they are not proper receipts, point of sale transactions over a period of time such that somebody would be able to build up a slush fund and be able to use that money for bribery. So companies are now looking at using data affirmatively as a compliance tool to try to catch these things before they become problems, and not only having to rely on hotlines or whistleblowers, and also not relying on the periodic internal audit function, which might not get to these things as fast as having these triggers in the system that pop up when somebody, a particular government official who's at the customs agency, for example, his name keeps popping up every other month for a high-end dinner or meal, looking to see whether their sales and marketing people are even over in that area using their Concur travel data to make sure that they're sort of triangulating where people are when these expenses are happening. So there's ways that we can all sort of encourage our clients and not be just doom and gloom with the data to ensure that there are compliance measures. And that goes into the DOJ's recent, I think it was in April of this year, Tools for Effective Compliance program. That goes into, is it really something that's created to detect fraud, right? And if you're just waiting for hotline calls, then perhaps that's not the best avenue.
And Jamila, on that point, I think it's interesting, and I too sort of advise clients in this space, but once you've created that data, right, in the same way that we see all this BSA data now being used more to prosecute banks, I think, sometimes than, or we're seeing the opioid data be used against the pharmaceutical distributors. You're not creating it underprivileged. It's there. So, do you do more harm than good if you red flag and you don't follow up on those expense issues?
Yeah. I think it's definitely a risk assessment for each company where they stand. But yeah, especially the larger publicly traded ones probably deem it less of a risk than the smaller ones. So it's definitely a risk question, but it's a good question.
Well, the answer to number 3 here, does the corporation's compliance program work in practice? You would like the answer to be yes. If the answer is no, the no should not be because we don't bother to follow it.
Right.
That at that point, this is no longer a safety line, but a noose. Jack, I know you advise clients in the corporate compliance space too. Do you think that effective compliance, and particularly being able to take advantage of the guidelines, are companies now in effect being compelled, or as a practical matter, should they be analyzing their own data? Because they get the first look at it. They're going to see it before the government does. Is this something they really need to be doing?
I think it depends a little bit on whether the client is an organization that is one of the haves or the have-nots. That is, large publicly traded companies that are well capitalized, that have significant resources, experienced compliance officers, sound and hopefully well-paid outside counsel. Those kind of folks, absolutely. People who are among the corporate have-nots, smaller entities without those resources, perhaps of less sophistication, I think need to be much more conservative about what they do, because otherwise they're just going to end up creating a perfectly admissible trial exhibit against themselves.
Well, and in fact, the revised DOJ guidelines recognize this. I mean, they recognize that everyone doesn't have exactly the same resources available, and they don't expect companies to put themselves out of business spending on compliance. But if maybe in some circumstances the line between haves and have-nots isn't as clear. I mean, being the smallest in your field, the one with the lowest profit margin, et cetera, that might give a good argument. But what happens if your client is using data analytics in other areas of its business, but is not looking at data it's already analyzing for other purposes? It's not looking at it in the compliance area, or it could use some of the same tools at a minimal additional expense, reach out and be analyzing. Is anybody going to feel comfortable explaining that little gap to the government?
Well, like you said, I mean, that's great intent evidence potentially for the government, because presumably if you're using any tool, including a data tool, for your benefit, whatever you decide that is, and if you consciously avoid using it for something that you perceive might be to your detriment, that is a reasonable step towards establishing, at least awareness, if not willfulness.
Well, and in one of the False Claims Act cases that I mentioned earlier, where the provider was using data analytics to identify candidates for higher complexity classifications, they did it only where government reimbursement was available. Those were the only patients that were analyzed. Nobody else got a look because there was no additional money to be made that way. That featured pretty prominently in the complaint. I want to keep the trains running on time for Joe. We're just about at the end. I didn't know if anybody had a question or if you're all just really grateful that we're going to stop talking about data now. Okay, thank you very much.